Okay, so we're going to get started with our next panel. I am Amy Schulman from the law firm of Birch and Stolberg, which represents unions and individual employees. The next panel is pay equity and reverse preemption developments. If your brochure refers to immigration, that will be for another panel on a later date. But today we're going to be sticking to the very timely subject of prior salary as a factor other than sex, pay equity and prior salary disclosure laws, and employment law federalism. And the esteemed panelists who are going to be imparting their knowledge and experience are, first we have Victoria Wooden-Chavey at Jackson Lewis. Next to her, we have Christopher Wilkinson, who is a partner in the DC office of Orrick, Harrington, and Sutcliffe. In the middle is Rachel Byen, who is a partner at Outten and Golden. And next to Rachel, we have Matthew Thompson, who is a PhD with Charles River Associates. And last but not least is Roger King, who is with the Human Resources Policy Association. They each have impressive bios in the materials that you have, and I encourage everyone both to look at their bios and to read their materials. They're very helpful and informative, and I'm going to turn the panel over to Victoria to get started.
Thank you, Amy. And good afternoon, everyone. We're thrilled to be here to present a couple of hours on as Amy said, is an extremely timely topic. It's also one that is interesting as it relates to case law developments, legislative developments, and policy developments, and this panel is well equipped to discuss all of those. So we are going to proceed with our presentation, but we do invite you to ask questions and provide your commentary or insights along the way. I can't see some of you on the right side of the room, but hopefully my colleagues down toward Roger can, so please just let us know if you have something that you'd like to ask about or discuss on this topic, because we welcome your input and address that. So first, Rachel is going to kick us off with talking about prior salary as a factor other than sex under the Federal Equal Pay Act.
Good afternoon, everyone. So I'm going to talk a little bit about the Equal Pay Act. First, give just a general introduction, and then I'm going to talk a little bit about where the courts are going with respect to consideration of prior salary as a factor other than sex. So the Equal Pay Act was enacted in 1963 before the Civil Rights Act. And its purpose was to end the serious and endemic problem of employment discrimination in private industry, and to carry out a broad mandate of equal pay for equal work regardless of sex. And at that time, the women earned, I guess generally speaking, around 60% of what male comparators earned. So that gap has thankfully narrowed largely since then. However, these pay disparities do continue. And even controlling for the most relevant factors, including experience, education, occupation, industry, women still continue to earn approximately 80% of what men earn. And so by some estimates, the wage gap costs women in the US over $840 billion a year. So let's talk a little bit about some of the important features of the EPA. So unlike Title VII, which has this burden shifting approach, under the EPA, it's a more straightforward approach where the plaintiff has an initial burden. It's a greater and higher burden than under Title VII, where the plaintiff only has to make a prima facie showing. Here, the plaintiff has to show that the employer has paid male and female employees different wages for substantially similar work. There is no intent requirement under the EPA, and that's a really significant difference under Title VII. So if the plaintiff is able to come forward and meet her burden, then the burden, or then essentially the employer has certain affirmative defenses that it can raise in response. And there are 4 that are set out in the statute. The first is the employer can point to a seniority system that caused the disparity, a merit system, a system which measures earnings by quantity or quality of production, and then this 4th catch-all exception, a differential based on any other factor other than sex. So there's been a lot of litigation over the years about what does this 4th catch-all encompass. Is it as broad as it sounds, or in fact, is it cabined by the purposes of the EPA, by the sort of legislative history around the EPA, or even just using statutory construction by the other exceptions that are listed with it. So those are some of the debates that you see play out in the courts interpreting that factor. And so what we're going to focus on is just the question of whether an employer can look at prior salary as a factor other than sex in setting pay rates. So I would say that there's a pretty stark contrast in where the courts have landed on this question. You have the Ninth Circuit in a very recent decision, en banc decision, overturning its prior decision. The case is Rizzo versus Jovino, and it was decided just this past spring. The Ninth Circuit said no. Prior salary, whether you consider it along with other factors or standing on its own, cannot constitute a factor other than sex. And so in the Ninth Circuit's view, a factor other than sex is limited to legitimate job-related factors, such as a prospective employee's experience, educational background, ability, or prior job performance, for example. Because prior salary is not job-related, therefore it's not a valid explanation for a pay disparity, and therefore it wouldn't, it can't serve as an affirmative defense for an employer's, for different pay. So the Ninth Circuit reaches its conclusion through various different explanations. You know, it does use principles of statutory construction to conclude that the definition of the 4th catch-all has to be cabined to, you know, what the first 3 factors are basically getting at, which are all, relatively speaking, job-related factors. The court also looked at sort of the legislative history surrounding passage of the EPA and its goal of eliminating pay disparities. And so to say that you can set pay based on what has traditionally been recognized as a driver of pay disparities, just looking to the prior salary, is problematic and could not have been what Congress intended. But I think that really what the Ninth Circuit does and what the thrust of its decision is looking back at what the purpose of the EPA is. It sees it as a sort of an affirmative, proactive measure to correct pay structures that are causing these disparities, and not as sort of a passive vehicle that would enable an employer to point to any sort of business-related justification for the disparity. The goal here is really, when we find these disparities, unless we can point to something that is, you know, truly related to the job, the law says no, that disparity can't exist. And so the court analyzes or looks at other decisions from other courts that have allowed employers to meet their affirmative defense by pointing to business-related justifications that are broader than whether, you know, something that is truly job-related to a whole host of other justifications. So long as they are legitimate business justifications, other courts have said that that is sufficient to meet their burden. And the Ninth Circuit said that, you know, that's too broad, that is going to enable employers to, that pay disparities are going to continue to exist, which the EPA wanted to root out, and that there are always going to be economic decisions that employers make, but that doesn't necessarily mean those decisions nonetheless can still be in conflict with a statute whose goal is to end discrimination. And so essentially, the Ninth Circuit rules out business justifications as a means of defending against disparate pay rates. So I think that probably on the farthest, the greatest contrast to the Ninth Circuit's recent decision is the Seventh Circuit's position on this, which is essentially that any business justification, whether or not it's legitimate, can serve to justify a pay disparity. And so this was a case back in 2005. It's Wernsing versus Department of Human Services, where the Seventh Circuit said prior salary is always a factor other than sex, and really took a position that the market is neutral, and that if because of the market, an employer can pay a woman less for essentially performing the same work as a man, that is not discrimination because of sex. That is discrimination, or that is a decision, a business decision that the market supports. And the Ninth Circuit sort of takes issue with that and says that that sort of market forces theory, in its view, has been rejected by the Supreme Court, which way back in 1974 kind of looked at that justification, the market forces theory, in a case against Corning Glass, and did reject it. And so I think the Ninth Circuit sees the Seventh Circuit's position as in conflict with what the Supreme Court held many years ago. But I think that they have really fundamental different views about, one, do we see prior salary as sort of inherently a tainted variable, a tainted factor? The Ninth Circuit says yes, it is. I mean, we can look at studies that have shown that when prior salary is used to make pay determinations, because women have historically been paid less than men, those prior salaries end up with them, getting being assigned pay rates that are going to put them in a disadvantaged position vis-a-vis men. Whereas I think from where the Seventh Circuit is coming out is that it's not necessarily a tainted variable. There could be evidence showing that in her prior position, her prior salary was based upon sex, and therefore there could be a discriminatory explanation for why prior salary shouldn't have been used with this current employer. But you're going to have an expert, you're going to have evidence showing that. We're not going to just assume it. And so that burden is on you, plaintiff, to prove, and not on the employer to disprove.
So one of the things that I'll do is jump in and provide the other view of Rizzo. And that is, remember the old adage, bad facts make bad law? This is probably a great example of that adage. The salary system, or the salary setting system that was at issue in the Rizzo case was this, and actually I'll just read it straight from the decision. This was a situation where the Fresno County Superintendent of Schools had a policy, and that policy was this. It was a standard operating procedure 1440, which dictated that a new hire's salary is to be determined by taking the hired individual's prior salary, adding 5%, and placing the new employee on the corresponding step of the salary schedule. Now, how many people here have a salary system that sets prior salary solely on that basis? Anybody? Anybody? And that was the type of salary system that was at issue in this case. So it's certainly a situation where the Ninth Circuit, in en banc, said that in that particular situation, cabined under these facts, that where prior salary was solely the determination under this particular system, that in fact was different. Now, another feature of the Rizzo case, which is interesting, and we talked a little bit about this beforehand, is that the court said that this decision is based on this particular, under these particular facts, and goes out of its way to say that it ventures no view at all on the notion that in individual salary negotiations, that prior salary can in fact be a reason to meet the affirmative defense under a factor other than sex. So with sort of that big hole that's left in the decision, I think it's going to be very difficult, and we talked about this, and I'd be interested in Rachel's sort of thinking that in a situation of where there's individual salary negotiations, I'm now applying to be an associate at ORIC. In those determinations, whether ORIC would be able to consider my prior salary solely based on Rizzo.
I think that the Ninth Circuit, the Ninth Circuit does explicitly say we're not weighing in on an individualized negotiation where someone volunteers their prior salary or where that's a component of the discussion. We're going to leave it to courts to address that set of facts head on. But I think that they were doing that because those particular facts weren't before them, and it wouldn't have been appropriate necessarily to opine on circumstances that weren't that wasn't actually before the court. So I don't really think that they are. In doing that, I don't think they're saying that that there would be a different outcome there. I think that if you carry this rule forward into those individual negotiations, if the decision is based on prior salary alone, even if it is part of an individual negotiation, I think that's not going to be permissible under this decision. There's a part of this decision where the court says, well, unless the employer can really point to a way that prior salary is job-related, so it's sort of a proxy for other factors that are job-related, then maybe that could pass muster. Then that could be a different set of facts. Obviously, that wasn't the case here, and I think that is still going to be very closely scrutinized by any court, where an employer says, well, yes, I did use prior salary, but it is a proxy for these job-related factors. They'd really have to do a very good job of showing how they're connected and a close connection.
I just have one comment here on internal job applicants. How do you deal with that phenomenon where the employer obviously knows the comp history? Does this law apply, or does this analysis apply?
I think, the ninth, there is a footnote, I think, saying that even though this case had to do with a job entry situation, that it certainly would apply to other points at which, salary is considered. So I think that they did anticipate that this would apply, whether it's, you're first coming to a job or you're at a juncture during the job where there's going to be a decision on pay.
Yeah, I don't think there are any cases on point on this issue. I would suspect in any sort of decision, practically speaking, it'd be very difficult to enforce the type of notion of where prior salary was not used as a determination of making an internal decision, because it's just there. People know it. People know either your salary grade or your particular salary level. So I do think that while the courts may eventually get there, I certainly don't see practically how employers would be able to enforce that. Again, because again, and I do appreciate the fact that when you're looking at it as solely the basis, maybe somebody again has that, that may be a place where somebody can say, okay, well, that's exactly what, Rizzo was supposed to address. But in a situation where, of course, in most determinations of salary determinations for internal people, there are going to be a host of other factors that come into play. And I don't know if you had.
I wanted to comment on something else, Rachel, that you had mentioned, and that is this potential reference point of prior salary as actually being job-related or business-related. And I think it's true across the board as a practical matter that many employers use benchmarking studies to look at market data for what their competitors or others in the community or in the industry are paying for this kind of job. And it seems to me that given the prevalence and I think the unchallenged reliance on that kind of benchmarking market data, it does seem to me that an employer who says this individual's prior salary in this job is actually job-related or business-related might be a compelling argument if they're also using more generalized benchmarking data. I don't know, Rachel, if you have any comments on that, but I'd be interested in them because I think as a practical matter, that benchmarking reliance happens all the time.
Yeah, I mean, I think certainly using the benchmarking data would be a much more, sort of a safer bet, I think, than, and largely relying on that than, relying on what individuals say their prior salaries were. But if those two are used in conjunction and it appears that the salary is sort of within that range, I mean, I still don't quite know how you could say that necessarily that the prior salary is job-related. So I'm maybe missing that point.
Well, I think that, I guess what I'm thinking is that the prior salary would be one piece of evidence of what the market pays for this job.
Right.
So it's related to the job in the sense that it provides general information about what this job is worth in the marketplace.
And I think it goes to the greater question of again, the factor other than sex, the notion of business relation versus the notion of job-related. And I do a lot of federal contractor work, so I've been in front of OFCCP quite a bit. I was actually their lawyer for a number of years when I was with the government. And in a number of audits, the OFCCP takes the position that market data in and of itself is tainted. So based on the taint of market data, that if you use market data, that it's considered to be a tainted variable and it should not be, for example, in a regression analysis. It's a position they've taken, I know, in a number of audits. I don't think you're going to see that position moving forward under this new administration, but certainly there are arguments out there that market data in and of itself can be considered tainted. There was a question, a hand up. Yeah. I know you were going to jump in.
It impacts the position of the person on that benchmark. So if you're using prior salary and you go to make an offer, you're going to look towards the bottom of the benchmark, and then it's just perpetuating itself as it goes along. So I think, I thought that was a good point, but you could see how it could actually play itself out in a negative way.
But it should regress to the mean, right? I mean, it applies both to men and women.
Yes, but
I mean,
if women have lower salaries for the same job, then they're going to come in lower on the benchmark when they get hired.
No. Oh, I see. You're saying that is perpetuated from the
Exactly.
previous position.
Yeah.
I think there's a couple interesting pieces with it in terms of from the economics. I mean, to argue that prior salary doesn't have any job relatedness if I'm coming over from a similar job, yes, there may be some taint in it, but there's also a lot of information in the salary in terms of prior performance that you wouldn't have at the previous company and other information like that seems to be job relevant, including in there. Now, I think the question that I have as a researcher is, starting salary and where someone comes into the company, I could see has a big impact on what their pay is. Over time, when does that go away? So if I'm looking at someone who's, been at the company or a level within the company that's much higher, and the argument that the difference there is still because of starting pay, that's a little bit harder to argue, I think, because you've observed this person over many years. At that point, they are presumably doing the same job. But if I'm looking at entry level, it's a whole different story because now I'm, an associate coming with 3 years from one law firm versus an associate from another law firm. What they were paid does tell me something about their performance as well.
Right. And I think that really goes to the job relation point in the context. And I think Rachel and I will agree that if that gap existed or persisted for 10 years, certainly under California law, where it is written into the statute that it must be related to the job in and of itself, and then there must be a business necessity, and we'll talk about, the state laws, and it must account for the entire difference, that if it persisted for 10 years under California law, you're probably a problem. Now, the question is when you think about year 2, year 3, and there are initial considerations that go into how that starting salary was, I think you do have better reasons for why those differences exist, but if they persist, for an extended period of time, I do think that's going to be an issue.
Can I ask something, maybe Rachel? I don't think the Supreme Court has ever rejected market forces. I think that's it's not your read, it's the Ninth Circuit's read, but it's a local read of the Corning Glassworks case. That was a case where women were barred from the work by virtue of the so-called progressive laws of the time. So the men had that work, and they insisted on a premium for the work. Then post-1966, after the Equal Pay Act, they continued that differential, and the company had this lame justification that they had to pay market rate. That was a market rate where women were excluded from the relevant market. I'm just not sure it applies in a contemporary setting where you don't have job segregation. Number one. Number two, the statute speaks about a factor other than sex. It doesn't speak about job relatedness or business necessity. Other statutes do, but not that Equal Pay Act statute.
I mean, I do see it in the Corning Glassworks case. Yes, there was a particular set of circumstances there where the women were entirely excluded from performing the night shift work. Then at a certain point, they were allowed to do the work, but they'd never increased their pay to what they had been paying the men doing the night shift work because the women would accept the lower rates. So there's a quote in that case where the Supreme Court said that the company took advantage of such a situation may be understandable as a matter of economics, but its differential nevertheless became illegal once Congress enacted into law the principle of equal pay for equal work. And I think that there are other places.
Again, they continued an unequal differential after the effective date of the Equal Pay Act.
Right.
And they can't justify that on the grounds that's what they had to pay men. That's not the claim here. The claim here is it's an objective factor, prior salary, matching prior salary. I'm not
Right, but
speaking
they
to the policy.
justified it based on, we had to pay men this greater amount because we had to get them to do this night shift work, which, and so I think that, and the men wouldn't accept anything less. So I think that's where the market force theory kind of gets into it. But the women would accept less, so that's why we're paying them less. And I think that's where the Ninth Circuit picked up on the rejection of that theory, and other circuit courts have picked up on that. I think it's this idea that you can point to market forces, sort of generally speaking, I think is except in the Seventh Circuit, I think has been rejected. But there is I think that. That's sort of at the extreme end, and then there are all sorts of business justifications that I think are more nuanced than the market forces theory, and in lots of circuit courts, a business justification that sounds bona fide, sounds legitimate, doesn't sound sort of like a cover-up for sex discrimination. It's going to be, you're going to be able to point to it to assert your affirmative defense. As long as that was really the reason why this disparity occurred. So you really can't come up with something after the fact. It has to actually have been the reason for the disparity. And so that, that sort of goes to the burden on the employer in these cases.
Question here.
Yeah, just talking about class groups or individual people who claim. Because what if I want to pay someone more because I like them?
Well, under their
What if you want to pay
Somebody-
someone more because you like them?
right. Well, I think in the Ninth Circuit, that's not really going to be job related, and I don't. It's not one of these. It's not one of the 4 exceptions under the Act. And so, if you have 2 people, a man and a woman, doing and the plaintiff is able to show that they're doing substantially equal work, well, there isn't an affirmative defense that I like them more.
So I think.
Except maybe in the Seventh Circuit.
Well,
I think that could pass muster there.
So I think in a situation of where it's just your subjective notion of whether you like them more or not, I mean, again, that's going to be a jury question, I think. That's something that a jury's going to have to say, okay, well, because I like them more, that's the reason why, and that meets their affirmative defense. You're not going to get, I don't think you're going to get summary judgment on that. But I do think that for example, let's say sales positions, where there are objective criteria that relate to, business savvy, or that relate to other kinds of things that would relate to make you a better salesperson than not. If you had on your application, I am a, and I don't know the, I used to know all the Myers-Briggs things, but if yours is I, and you're applying for a high-profile sales position, then it probably is looking more closely to job relatedness. If it's to rip heads off of chickens, then which people do at meat processing plants, then it's probably less of a job-related factor. So I'd like to think of it more as a continuum. But again, I don't think you're going to get summary judgment on I like the person. I think you would agree with that. You would get summary judgment on I like the person better.
Except maybe in the Seventh Circuit. But I think there are a couple of really interesting practical points here. One of them is that, as Rachel said before, the EPA is not an intent statute. So whether you had a pure heart and you had no interest in discriminating against a person is not the issue. So if you like the person, that's important because it may be an explanation for why the salary was set the way that it's set, but we're not looking to see, as we are in most discrimination cases, whether there was that intent to discriminate. And in EPA cases, there are, I think as many of you probably have seen, certainly I have in my practice, especially when we're talking about setting the initial salary, there is not a lot of evidence to support what decision is made. So by the time the litigation is filed, and these cases don't go through the administrative charge phase, so sometimes the cases are filed pretty quickly, but not, sometimes a year or more can pass. Everybody's scratching their head trying to remember or piece together why a salary was set the way that it was set, and why people hired at roughly the same time, male, female, are paid differently. And it's a lot of, just as Rachel said, it doesn't work if you kind of make it up after the fact. In my experience, we're often trying to put that story together well after the fact. And when there is this tightening, like we're seeing in the Ninth Circuit, and even in other circuits too, of what that factor other than sex can mean, it really, as an evidentiary matter in the actual cases that we're litigating all the time, creates a real issue. And it may be that these cases are just going to be less amenable to summary judgment, and they may have to get tried, although of course we know cases don't get tried anymore, and if they don't get resolved on summary judgment, very often they're going to settle.
Comment, and Rachel made this point. It is very hard to make out a equal pay act prima facie case, because you have to have male and a female in jobs involving the same level of responsibility, same skills, and only then you look, that's the prima facie case, and only then you look at four narrow affirmative defenses. In most cases, it is very hard to make out the prima facie case.
Right.
Unless it's different on the state law, but that is the federal equal pay act.
Yeah, I mean, I think there's that fight over who the right comparators are. And I think my experience is it depends on which court you're in and which judge, and there often is a leniency toward viewing the plaintiff's prima facie case as having been met and then throwing the ball back to the defendant to make out its defenses.
And I think,
Piggybacking just in terms of the data component, going back and recreating, it's often much easier to have these two people, why did you pay one person more than the other? Now think of, you're doing a regression analysis. You need that on everybody in terms of the factors that went into that decision process. Oftentimes you don't have that, so what's your next best thing that you have? Starting salary, which you do.
So, Sam, I think you raise an excellent point. The burden here is a high burden. But from a policy perspective in Washington, the employer community is watching carefully what the Congress and perhaps the new Congress may do, not only on this particular statute, but in the whole arbitration, Me Too movement area, whether it be NDAs, what have you. So the long-range policy implications of this discussion, potentially, given a Democrat-controlled House, and who knows about the Senate, perhaps leaning are considerable. So I think you're going to see a reexamination of these statutes.
I do want to just touch on it, and we'll go to the question just 1 second, and that is the question of substantially equal or equal jobs really depends sometimes, again, on the nature of the industry. Again, for meat packing plant, 2 people are sitting next to each other, very easy. In high tech, we have a lot of high tech companies or clients. In that situation where you have software engineers who are sitting next to each other, that becomes a much more difficult question. So it's a question that.
If you're advising employers, you better be risk averse.
What? Well, certainly in the States, you want to be risk averse with the changing laws.
People who are doing basically the same work, it doesn't matter what their titles are, you're in troubled water. You're not re-examining the salary differentials.
Oh, of course.
Yeah, absolutely.
Sorry.
Hi, Arlene Zweier from the State Division of Human Rights. I happened to attend a couple of nights ago a CLE on implicit bias, which we all have. The point was made that we all make judgments about a new person we're meeting within 7 seconds of meeting them. Some of those judgments may have to do with unconscious biases that we have on the basis of race, gender, or some other category that we consciously may not discriminate against or make our decisions based on. And so regarding the issue of intent, there may not be intent to discriminate, but there could still be implicit bias. And regarding the issue of looking at a person's past job performance, at that same CLE, there was reference to a study, and I'm not sure exactly if they used testers or how they did it, but they had men and women doing the same exact tasks in the same way, making the same statements, and the men, the evaluations of the men on those activities were positive, and for the women were negative. So, you may think that an area is quote-unquote objective, but it's not necessarily. There may very well be implicit bias involved.
So I want to address the second point, and maybe, Mark, you'll back me up, or maybe you won't on this. But the data for the regression analysis that we typically do when we go into companies, we do pay equity audits, tend to reflect that women are actually receive higher performance evaluations than men. And that is certainly what we've seen on the ground with regard to the performance, with regard to the data that we've seen on the ground. And I don't know if that's what you've seen, but
So it is consistent. The other piece that's hard with, and it depends on the measures, but one of the things that you come with performance is many companies have 5 rankings. The low, 2, 3 in the middle, and the very high. And if you look at the distribution of the employees, they're in not typically the highest, but the next 2 below that, disproportionately. And so performance ratings are very hard to use to differentiate skills and abilities and qualities, because they are so aggregated and managers don't want to have tough conversations with employees.
Yeah, I have an interesting case right now where the women were, on the whole, rated higher in their performance reviews, and yet they were paid less.
Yeah.
And the performance is supposed to be tied to the pay. That's how their system works, but generally speaking, across different managers, we're finding that the pay is lower for women despite those higher ratings.
yeah, I think the takeaway there is what I always tell companies, and it's whenever you say you pay for performance, I want to see that. Because what I often see is that your starting salary is what's driving your pay differences.
Well, sorry,
Yeah.
in terms of, we do a lot of audits for companies as well, and one of the things that we typically will do is you'll look at, base pay currently, see what it is, see if there's a difference, then add in starting salary to see, is that difference today a result of where you started, or is there something else along the way that is happening?
Now, what do you do with performance reviews that are not very good? Because
So
Well,
again.
I just want to repeat the question. The question was whether, what happens when there were negative performance reviews and an employee's past when times were flush?
Positive, but they unduly
Sorry, positive when they were flush, but inflated, let's say, and when times reverse, you know, how do you correct course, or can you correct course?
call you in, Matt, but we don't want Rachel finding out about it.
So what is amazing, again, and this is work that I do with companies that are going through downsizing, you know, the performance reviews that have happened all along versus when you're now set, I have 20 people and I have to reduce it down to 5, it's a different performance review. It's a different process in the sense of, again, most people, because they don't want to have that conversation, put them at a average or above average, even if they're not performing well. Now I've got to make a decision. I'm going to keep my highest performers. I want to keep them. And so many don't use prior performance when they look back at making those decisions. They're looking at different pools. They're looking also at what's the company going to look like in the future.
And they ignore the prior evaluation.
I wouldn't say they ignore it because, again,
In case I don't want to join Rachel.
It's not ignored, but it certainly, you know, when I'm making a reduction in force decision, it's not about what the company is today, it's about what the company is going to look like tomorrow. So,
All right, so we'll keep moving. So next, we're going to talk about, and I think we can move the slide here, to prior salary disclosure laws, which are really one answer that we're seeing in the great marketplace of ideas to try to correct this persistent gender pay disparity. 1963, as Rachel said, was the enactment of the Equal Pay Act, and here we are 55 years later, and that pay gap is persistent, although it has narrowed a bit. So what we are seeing around the country, and I'm sure all of us are familiar with, laws that have, just in the last couple of years, it's amazing how quickly state legislatures and city councils have been enacting laws that tell employers that they may not ask an applicant for a job for prior salary history, that question on an application or in an interview is forbidden and may not be asked. These laws, to one of the questions, Roger, that you asked before, tend to, and I'm generalizing because there are all different nuances among these laws, which are getting passed and enacted even as we speak, I think. But they most typically do not apply to current employees who are seeking promotion or transfer. So these are just employees on the way into an employer, and these newly enacted set of laws, the salary disclosure laws, say that employers cannot ask that question in writing or in an interview. Sometimes the laws are explicit that after an offer is made, that would be an appropriate time to ask that question. Some of the laws say that after an offer is made and a compensation offer has been articulated, that would be an appropriate time for these questions to be asked. So this is a wave that I think is really just quickly moving across the country, starting in Massachusetts, which was the first law that became enacted, although oftentimes we've seen this long period before the law actually becomes effective so that employers can prepare, and are certainly calling us all the time to ask for advice on what to do about this. But again, generalizing among these laws, most of the time they do permit the possibility that an applicant will volunteer what their prior salary was. And in my mind, that creates a really interesting conundrum, because we're seeing from the Ninth Circuit decision that Rachel was discussing, this notion that prior salary is never going to be a job-related factor that can make out the affirmative defense under the Equal Pay Act. So if an applicant volunteers in the course of an interview, for example, what their prior salary was, probably because it was high, or they think that it was high in relation to what they're looking at, the employer is really going to be perhaps uncertain what to do with that, because in certain jurisdictions, as we now know, that reliance on that factor is not prohibited. In other jurisdictions it may be, but in any event, it's kind of a hot potato and employers may not know what to do with it. And I think that there is no great answer that I can give you to that question because this is evolving. One just piece of practical advice that relates to the comment I made before is I do think employers are well advised to look more carefully at their record keeping with regard to why offers are made. We often see, as I said, just an absolute empty folder when it comes to the information about why a particular hiring package was set the way that it was set. And even if the employer is sophisticated enough to have salary ranges, picking a data point, as you were pointing out before, picking a data point within the permissible salary range isn't necessarily obvious, and it's not going to be clear why a point was picked in one case and different in another. So that is just kind of a general overview of prior salary disclosure laws. It's also interesting to look at what are some of the positive and negative points among these. And I want to go back to your comment about implicit bias, which we are all hearing a lot about. And one of the criticisms of these prior salary disclosure laws is that without that hard objective data about what prior salary was, people may resort consciously or subconsciously to their assumptions about what an applicant is worth. And so there is a school of thought that at least, and maybe Matthew, this is something that you were alluding to before, having the data about prior salary is better than not having the data, because if you don't have the data, maybe you're going to rely on some implicit notion about what the value of this applicant is, and you would be better off with the data on the table. We know what it is, and hopefully we can evaluate it rationally and objectively and set a salary amount that is not related to and has nothing to do with gender and is documented in a way that allows us, if there is a challenge, to defend that.
I was
Matthew?
about to say, I mean, and to the extent of other programs that have been put in place, ban the box, those types of pieces where you're taking away information that's there, the studies have shown that, in fact, it increases the bias, not decrease, because of the implicit component. I have a lot of other information on the resume, and I start reverting to the means. And so, on average, women are willing to take a lower salary, or have been paid lower, or have had more separation from the workforce, which means they have lower salaries. And so, while I may not, explicitly think of that as I'm doing it, those creep in. If I have the information there, even if I believe that's under because of a gender bias, I can make the adjustment to correct it.
Yes.
Am I right in understanding these disclosure laws, they don't ban the employer from receiving the information?
Right.
Right.
That the employee provides. And typically, employees will provide, applicants will provide when they think it's to their advantage.
Right.
Male or female. And it may well be that in the Ninth Circuit, that's not going to be a defense if there's any Equal Pay Act prima facie case.
Right.
First of all, it's the Ninth Circuit. Secondly, the prima facie case is difficult. I received the information. If you don't give an employee that you want their prior salary, that person's not going to go to work for you. At the very least, again, if the person has any bargaining power, they are, and I'm sure it's true of everyone at the town here. Haven't had in-depth conversations with you, but I know if I want to hire Rachel away from Wayne Allen, I've got to at least match her salary at the Apple firm. And that is part of the, am I wrong about that?
No, but I think there's a flip side of that coin, which is that part of what we worry about when we worry about the gender pay disparity is just those who are actually hired, but also those who may not have gotten to the point of being hired, the pipeline. And so something, and I'm not espousing this view, I'm more telling you this is what some of the commentary is on it, that some believe that by, if there is a jurisdiction in which prior salary disclosure can be required, and an applicant has to disclose that, the reason often is to make sure that this person's salary expectation is in line with what we're planning to pay them. If they want $100,000 and this pay range is 60 to 80, forget about them. But what that doesn't account for potentially is people who are paid low, but maybe should be, their skills should be commanding a higher salary in the marketplace. So they may be excluded from a job that pays 60 to 80 because they're only making 40, and the employer says, why would we hire this person at that point? They're using that salary as a proxy for low performance, low skill, what have you. It may or may not be appropriate. But I think it also is true on the other side.
I could use the proxy as a terrific hire. I've got a person with the same skills and abilities, and I don't have to pay that person more money.
Right, so then we go back to the question, would that be a job-related factor or business? You'd be fine in the Seventh Circuit with that approach. Yeah, but the other side of that pipeline question is also one that I find interesting, and that is if there is an applicant who's currently making 100 and they're interested in the job that pays 60 to 80, the potential employer may exclude them from the pipeline because they're higher paid and they assume that they wouldn't want this job. So it's interesting to look at these things. Again, I don't think there's a perfect answer to it.
Which I think is, part of the problem with hiring and all of this, and the reason why the information's good is it's asymmetric. I know what I want, you know what you want.
Right.
We don't know what each other want. So to the extent of an employer that comes out, and I think this has been some aspect of this litigation, is these laws are, you have to disclose at least a range for this position. And so now as an employee, I know this range, and to the extent of if I'm earning $100,000 right now and it's a $60,000 to $80,000, I know that going in, and I may be explicitly making that choice because salary is not everything of a job. And so, to me, a lot of this is information is good. Even if it's biased, you can use it.
Requiring that the range be stated?
So, well, you do. Oh, so the question is, do you have a law that requires that the range be stated? Well,
Yeah, no, I was just going to repeat the question, but Chris did.
yeah, is there a law? Well, I mean, in California, if in a situation of where someone makes a reasonable request, you are required to provide the salary range of what the job pays. Now, query what salary range means. The guidance on this talks about, the average salary of the position or what you would expect to pay for the position. I still don't know whether that means the salary band. I don't know whether it's because salary bands in and of themselves can be very, very broad or very, very narrow. I don't know if it's average salary, then if you have a high flyer who's making, 50% more than everybody else, then that skews. So that's something I think that's going to have to be determined down the line. But to go back to another, and I don't know whether this has been accounted for also in this question of prior salary. My understanding and the way it's been explained to me by some quarters is that if women go first, they will always negotiate a lower number than men. Now, I don't know if that is the case, or if that is actually, but that has been how some people have explained to me that is one of the reasons as to why if you go first, men are always going to have a higher number, women are going to always have a lower number. So to some extent that these laws are trying to address this, whether it's true or not true, it is one of those things that has been explained to me as one of the bases for these laws.
Yes, question.
Just about the idea of asking about past salary. A question I've seen on applications is expected salary. Is that kind of a sly way of asking the same question? And is that permissible? Because it seems like it's targeted at the same thing without really asking the same question.
Yes.
So the question was whether applications that ask for expected salary are explicitly or implicitly an end run around trying to get current salary.
Yeah, I think certainly those questions which have existed in the past, but I think are being introduced now as an alternative to asking for your past salary. The question is what you expect to make here. Those are viewed as permissible because they technically don't violate these prior salary disclosure laws. But I do think they are subject to some challenge as well, depending on how the data is used, because it may in fact just be another way of asking the prohibited question.
The interesting piece is I think actually that might be more damaging than in terms of the idea of I'm trying to filter out people. If I come in and I say my expected salary is something, and those are the applications, and part of this is a cost component from an employer standpoint. If I'm taking in 1,000 applications and trying to get through them. I'm trying to narrow down to 3 positions. How do you go through that process of culling down to get to these? And so, the access of open information and what's there helps reduce the cost of recruiting overall. And from the prospective employee, I can always go out to Glassdoor or other places to start to gather some information in terms of what does this employer pay. As an employer, I can't go out to the former company and say, what were you paying? So again, it's the asymmetric information that can cause some problems.
Yeah,
Yeah.
okay, no,
I was
please.
just gonna say, to address what you were saying about how women are much less likely to negotiate or start from a high position vis-à-vis men, putting something on the application could, really, create some problems. I do think that your point, the more that the information is provided on both sides, then if a woman could come into a job with some information on what this employer typically pays people in this position, then they're going to be in a better position to negotiate, I think, and to pitch a number that is, on the higher end, but also consistent with what that employer is already doing. So they're not going to totally miss the boat then.
I take a different view. I do think asking about expectations does not violate any of these provisions. In fact, if you look at the Massachusetts guidance on their equal pay law, on their equal pay law, they say you can ask about expectations. So I do think that having an application could be maybe more difficult if I was in a situation of advising an employer. Perhaps, if it comes up in an interview or having somebody ask the interview question, if it came up in that sense, I think that would be okay.
So
go
I-
ahead.
No,
Please,
proceed.
no.
So I'm going to touch on this in a minute when we get into this patchwork of laws, but that's part of the problem. We don't know. And even the guidance in Massachusetts is not clear. So as a national employer looks at the landscape and tries to figure out some of these very ambiguous ordinances and poorly written state statutes, what have you, you don't know. So it gets back to a cost of litigation scenario and risk avoidance.
I haven't met anyone who's against pay equity and who wants to see women paid less than men for doing the same job. So I think we're all starting from the point that it would be a good thing if this pay gap were eliminated. And I think the main driver of these pay disclosure laws is to try to do something to address the persistent pay gap. Yes?
Is there anything wrong with an employer advertising a job at a specified pay rate, even though others already employed in similar jobs may be making a lot more?
So the question was, is there anything wrong with an employer advertising a job at a specific pay rate, even if others in the job are making a lot more at the company or employer?
I don't think there's anything wrong with the advertisement of that. I do think, though, if someone is hired at, they would have to be hired at the advertised pay rate, but then you're going to have a pay disparity. And if the newest person in the door is female and the existing employees in that job category are male, there's going to be a disparity that needs to be explained. And I don't think the advertisement, that's not an explanation, that's just a fact, but it won't explain the disparity.
And in fact, I think the real-life example is actually really the reverse. And this is a notion that we see in a lot of our, again, tech companies or financial services company, which is wage compression, which is if somebody starts off 10 years ago, and then they get basically a 2% hike in every position, and every year they get a 2% hike. For example, tech companies, a lot of years, they don't give pay hikes at all. It may be 3 or 4 years in between the fact that you get a pay hike. So then what happens is that the market then switches, and then all of a sudden you have to hire 50 cloud engineers. And then those people come in at a much higher rate based on what the market is. So that is a situation that's really more practical and what you're most likely to see, I would say, in the real world versus a situation versus the one I think you've mentioned.
So to a certain extent, what our members, and they're basically Fortune 50, Fortune 500 companies that are members of the HR Policy Association, they tell me this discussion's a bit academic, frankly, in this world we live in today of low unemployment and the need to go out and aggressively recruit. So one of the first questions they ask, what do you want to get you to come here to work for us? So it's sort of reverse. The companies are out there aggressively, thoughtfully, and very thoroughly recruiting. So this is an interesting discussion on one hand from a legal perspective, but I just got to tell you, whether it be tech jobs or other jobs or even lower paid, so-called lower paid jobs, the economy is driving the discussion really the other way.
Yes, question in the back?
So let's say there's a place of business and a woman feels like she's not being paid enough and she asks for a pay range and is told there's no such thing. Is that against the Equal Pay Act?
It's not a requirement under the EPA Act. I think that Chris was referring to a law in California that requires there to be disclosure of pay ranges or pay scales with a request like that, and there may be other states that require that, but it's not illegal under the EPA.
It's also never good to lie to an employee, so down the road, there's a lawsuit that's not going to be passed.
I agree.
Right.
Absolutely.
So, just overall, the main driver, policy driver of the pay disclosure laws is really just a desire to overcome the pay gap and find a way to do that. There's an interesting case in Philadelphia that is currently ongoing. And in that, Philadelphia enacted a pay disclosure law in 2016 along the lines that we're talking about here. And the Chamber of Commerce challenged the law and sought injunctive relief, seeking cessation of enforcement of the statute, which allowed for compensatory damages, civil and criminal penalties for violation of the pay disclosure law. And the Chamber of Commerce's argument was that this is a free speech problem. And the Philadelphia ordinance, the theory went, the Chamber of Commerce was arguing that the Philadelphia ordinance got at employers' ability to engage in speech, commercial speech in particular, with applicants. And just this spring, Judge Goldberg in the district court in Philadelphia essentially agreed with the Chamber of Commerce and did enjoin further enforcement of that ordinance. And there are some really interesting parts of that decision, but one of them, or among them, are the observations that the court made that everybody agrees that there's a persistent pay gap. No dispute about that in the record or otherwise. Everybody agreed to that. And everybody also agreed in that case, all parties that is, that the goal of the Philadelphia ordinance was to address that pay gap. And what the court said in connection with marrying up the purpose of the law and the actual law was an observation about the expert testimony that underlay the city's case that this was an appropriate restraint on commercial speech, which is subject to intermediate scrutiny. And the court said, I have carefully reviewed Dr. Madden's affidavit. Janice Madden, as many of you know, is a very distinguished expert. I have carefully reviewed Dr. Madden's affidavit, her impressive credentials, and all of the studies she has referenced. There simply is not substantial evidence to support the key inferences needed to substantiate her fourth and final inference that inquiry into salary history results in lower salaries for women and minorities. So the court essentially found this evidentiary gap in the justification of this ordinance. So that's where it sits now. I think certainly the conventional wisdom seemed to have gone in the other direction, at least among discussions that I have with people, is that there's kind of an assumption that if you prohibit questions about prior salary, then it's going to have maybe some impact, maybe marginal, maybe substantial impact on the pay gap. But this particular court found that the city of Philadelphia had not put forward the evidence that permitted a finding to be made along those
As I
lines.
recall, though, the other part of that decision is that you can ask,
Right.
but then you can't use the information.
Right.
So I remember reading the decision, and we're talking to our members about it, and we look at the decision and say, what was this all about? So, all right,
Yeah.
I ask you, you tell me, and then what?
Right, so the ordinance had what the decision calls the inquiry provision and then the reliance
Right.
provision, and the court did address those separately. But I think this decision is an interesting discussion of all of the policy issues that we're talking about. What is it that governmental bodies, whether it's state legislatures, Congress, or local city councils can do to try to address this problem, and Philadelphia tried something. The other thing I want to mention, and again, this is kind of great experiment with different jurisdictions trying to figure this out, is both Wisconsin and Michigan have enacted laws just this spring that essentially prohibit cities or localities within those states from enacting prior disclosure laws. And in the Wisconsin statute, which I think just became effective last month on signature of the governor, there's a specific finding that there is a an interest that is statewide in having employers and their applicants have an open line of discussion about salary history. So those two states are reacting to this issue in a very different way.
Yeah, that's state reverse discrimination and reverse preemption.
Right, so this goes right into,
Yeah.
Roger, I know what you want to say a
Well,
little bit more
but
about.
just a minute, though, but I want to go back to Philadelphia ordinance.
Okay,
So an employer gets information, but then can't use the information. Once an employer has any kind of indicia about an applicant that they may have obtained properly, but may be in and of itself tainted. If I learn how old Sam Estreicher is, and then I'm considering, yeah, well, no, I don't hire you, Sam. So just the ability to get the information and having it can be construed negatively toward the employer. So
Right.
there are all kinds of issues, I think, here.
Philadelphia decision has to be an outlier. The general rule is economic legislation is the legislature absolutely nuts. You don't have to prove that it's going to actually solve the problem. Could the legislators think rationally that it might solve the problem? I just don't, what's the name of the case, by the way?
So Sam's comment was whether this Philadelphia decision is an outlier.
Victoria, what do you
it's Chamber of Commerce versus Philadelphia, City of Philadelphia.
even if the Chamber of Commerce wins and sometimes they will lose. Is it on appeal, by the way?
Not yet, it's just been decided by the district court.
With regards to not being able to use prior salary in that case, does it say how you can't use it? Can it not be used to create your salary offer? Or, again, to me, it's information. So if I learn what your prior salary is in my interview discussion, I may probe more into what were you doing there? What types of responsibilities do you have? Why was your if I think it's lower than what it seems like it should be, tell me a little bit more. Let me gather more information about the process, which may have nothing to do what my ultimate offer is.
Perhaps not.
But it's, again, to me, it's a means of understanding. We're trying to match people to jobs and pay them appropriately, regardless, without
Right.
discrimination. And so that's why I was just wondering in terms of, does it say?
It's very broad language relating to reliance on the wage history at any stage in the process.
Victoria, are there any empirical studies or experimental studies on how these statutes work? Because the ban-the-box laws have, at least in their experimental work, have been shown to be counterproductive.
Right.
I just want to repeat the question. So the question was,
I don't have my,
was whether there are any empirical studies that show whether this type of legislation is actually effective in combating the problem it's attempting to solve, and the comment was that ban-the-box legislation has been counterproductive.
experimental work.
I'm not aware of any studies, Matthew. I don't know if you've seen them. My sense is these statutes are so new, and there are variations among them across the different 20 or so jurisdictions that have them. I'm not aware of any studies yet.
I haven't seen any studies on the salary component. I've certainly seen the ones on ban the box. And again, it's, My personal opinion is that they would be either counterproductive based on the studies on these other components or neutral.
The EEOC's done some work in this area, but not current. The EEOC has done some studies in the criminal recidivism and employment area, but not current on ban the box, to my knowledge. So I would like to jump into this conversation and turn it around just a moment. I'm here to espouse the radical suggestion that we ought to have uniformity in our labor and employment laws in this country to avoid some of the discussion we've just had here today as to what all these state and local laws mean. But I should say at the outset, thank you to NYU Law School for inviting me back on this topic. And Sam, thank you for having me back. It's good to see Evan and Marshall Babson and others.
Are you arguing for uniformity or for employment law federalism?
Well, so the question is, am I arguing for uniformity or federal or uniformity and federalism process? Well, let me get to that, if I could, Sam. So as I mentioned just a moment ago, I spent a lot of years in the private practice sector. I was 25 years at Jones Day and then went with my client, the HR Policy Association. We represent most of the Fortune 50 and a good number of the Fortune 500 companies in the country for labor and employment matters. We work with the Chamber, NAM, many others. And the employers that we represent might agree with many of the social objectives of these state and local laws. As I said I'm not sure, listening to our members, they have a great deal of concern about not being able to ask about salary history. There are many other ways to go about an intelligent hiring process. What they are concerned about is having to deal with a patchwork of literally hundreds and hundreds of different laws in a variety of ever-increasing areas. Leave areas, we've talked about salary history, sick leave laws, etc. And trying to manage a business with that many outliers continues to be a problem. And let's just drill into that for a moment. If you are operating in a multiplicity of states, and many of our companies in all 50 states, the amount of resources that you are expending on regulatory compliance certainly decreases from the potential ability for increased wages and benefits and better recruiting, certainly infrastructure, and other ways to spend the money available. So it also has a corresponding impact on how we move jobs around in this country. And I've heard this discussion, and I'm sure perhaps many of you in this room have. Why should we locate our plant or our business in a blue state such as California that has this ever-increasing number of very aggressive labor and employment laws? Let's just go to Nevada. Let's go to Arkansas, or let's go to the South, let's go to Mississippi, et cetera. The cost in that job relocation, both from a social and economic perspective, I would submit to you, is negative. One of the real principles this country was built on, in the paper I've submitted, we go back to the Federalist Papers in Hamilton. One of the real central strong points of how this country was put together is a strong central government and avoiding the so-called colony approach. And that's, I think, and I would submit, has served us well overall in the economic development of the United States compared to our fellow countrymen in other parts of the world. You look at the European model where we've had at least until the entire European continent came together, maybe, on an economic environment, a very isolated state approach, state-by-state approach, country-by-country approach. We've not had that here. So one of the issues that I think needs to be addressed is, can we and should we have more of a preemption model, if you will, in going about our federal and state laws. And let me just go to New York City for a moment, given our current venue. The city council of this city has delved into a number of areas and wage ordinances and the like. Is that helpful? Now, you can argue, and I understand the argument, well, nothing is getting done in Washington, so we're going to do something here in Sacramento or New York. Perhaps. But if you take that continual stream of enactments, does it reach a point of interfering with interstate commerce? Does it reach a point of sending jobs elsewhere, outside of the country perhaps, or certainly depress job creation? So I submit those as just things to think about, but that's one of the central issues that we're really coping with in Washington on a policy basis. Of course, at the other end of the spectrum, we have the more conservative element in the Congress that doesn't want more federalism, doesn't want more control from Washington. We hear that. We don't want to give these people in Washington any more power than they already have, that we already live in the state of regulation way too much. So it's a difficult discussion to have, but it's one that we need to have on an ongoing basis. And a solution that I suggest to you is one of a safe harbor approach. It's discussed in my paper. It's encompassed in a proposal by Congressman Mimi Walters from California, wherein, and this is a leave statute, if you will, or a leave legislative approach, wherein if a entity, an employer, met certain federal standards, progressive federal standards, I would submit, that employer would be isolated, insulated from state and local initiatives. The employer could decide not to go to the federal standards and subject itself to the patchwork of laws that might be desirable from the employer's perspective. So that's one approach that we are strongly suggesting. Another event that has to happen here from our perspective is that the General Counsel of the National Labor Relations Board, Mr. Rob and his colleagues, need to start looking at some of these state and local initiatives that border into the labor area. The prior General Counsel of the NLRB did not have the word preemption in his vocabulary, and I like Dick Griffin a lot, but you saw virtually no activity from the National Labor Relations Board to protect the National Labor Relations Act and its broad reach, and that's an issue. So we'll see what happens there. Another concern, and one that probably has some positive attributes, and it's mentioned in the paper, is the ability to use the ERISA statutory preemption, which is really the gold standard of preemption in the federal laws, to encompass not only the traditional health law benefit area, but there's case law, including a Sixth Circuit decision, that says the preemption part of ERISA may also reach leave laws. And Nationwide Insurance Company successfully fought off the potential reach of the Wisconsin leave law using the ERISA preemption standard. So one opportunity I know that a number of large companies are looking at as they are being literally inundated with these state laws in the leave area and other areas is to see if the preemption provision of the ERISA may be helpful. So those are some thoughts. I mean, we will continue to look at what's going on at the state and local level, but the discussion we've been having here today and will continue to have is a challenging one. And how you comply. I mean, even if we get the information, like in Philadelphia, but we can't use it, we're not sure how we could use it or what it means, how far can we go, this patchwork of laws leads to increased litigation, choice of law statutes, et cetera. So that's also a problem. So I just submit to the panel, we, I think, should be looking more on a uniform basis. Where we land, we can discuss. Well,
The
as you know-
question was whether you could elaborate on what you meant by wanting more National Labor Relations Act preemption.
Right. Sam, as you're well aware, the preemption in federal labor law is very broad. It's not by statute, it's by case law, by Supreme Court case law. So historically in this country, our labor law has been established and enforced on a uniform federal basis, with the National Labor Relations Board being the chief enforcer. So that's what I'm talking about. So if, whether it be New York, California, any other state or jurisdictions within those states are delving into the labor area, the board historically, as a general rule, has been very aggressive in litigating, if necessary, the existence of those statutes and arguing they're preempted. So that's what I mean, that hopefully this board will go back to that standard. And whether you're Republican or Democrat, ultimately, whether you're in labor or management, ultimately, again, back to the premise, we need to have strong federal labor and employment laws that we all can understand, we all abide by, and they make some sense.
I think your proposal for me, I had, you know, it raises some questions in my mind, which are, first, would this proposal be the same regardless of who's in control of Congress? So if you had the Democrats in control of Congress, would this still be something that your clients would strongly support? And also, I think that, you know, a lot of our labor and employment laws derived from the states. California, New York, they had wage and hour laws before there was any federal law. They have always been the incubators of these laws. They've always been, you know, because these issues are really at the heart of what states do and the kinds of laws and regulations that they've always, you know, been focused on. So I think, in fact, you know, historically, the federal government has played less of a role in labor and employment legislation than the states have. And I think what's also sort of problematic to me is that, you know, you have, the states are really driving a lot of the more progressive laws here. And to sort of, you know, stop that process, you know, because of the fact that, you know, some states come up with a different rule than another, and because it's hard to comply with or stay on top of all the various laws or permutations, I think, you know, I think it would really stymie a lot of creativity. I think it would really harm workers. And I think that what a lot of these states do that are really pushing the envelope on these laws is they're trying, they ultimately do lift all workers across this country, because what I've seen or what I've heard from a lot of employers is that they do have to look at what the most stringent requirements are if they are going to be a national employer, and they do have to keep those most stringent requirements in mind in setting their policies. They don't look to sort of what are the lowest set of requirements are. And I guess just to, one final point is, yeah, I think some, you know, states or cities have come up with different ways of approaching this issue, but a lot of times what you see is one state will look at what another state has done and decide, look at whether it's worked or not, and oftentimes you see a lot of sort of copycat laws. So I haven't seen, I've seen a lot of commonality here in terms of the states or cities that are trying to look in particular at this issue. Yeah, some might be broader than others, and some might have a somewhat different, you know, set of regulations. But I think generally speaking, I don't see them as being, you know, so dissimilar that it would be hard for an employer to attempt to comply with.
So would you like to work in one of our company's compensation offices for a week? And I think you would draw a different conclusion. But I want to go back to your first point. From our perspective, the HR Policy Association perspective, it makes no difference who controls Congress. I want to make sure that's clear. I mean, you can play the Republican-Democrat game, and I get that. But our laws over the years were enacted by various Congresses that had various majorities of either party. That's not the question. The question is bring some rationality and uniformity. You can have a very liberal approach on leave, a very liberal approach on asking about pay compensation or restrictions thereof. That's not the point. The point is to have some uniformity so we can be more efficient and more thoughtful in the way we conduct business. As far as the origin of our the origin of our labor and employment laws, you can go back and forth. Taft-Hartley is clearly a creature of the Congress, not a creature of the states. The Fair Labor Standards Act goes back 1930s, et cetera. That's a federal statute. So I wouldn't agree with you that the states have been a great incubator of labor and employment laws. In fact, I think I can make the argument just the opposite. You look at Mississippi, you look at many of the southern states, just the opposite. They have been very restrictive, frankly. And but for federal enforcement, whether it be at the EEOC, the NLRB, the Department of Labor, we would not have the labor standards we have in this country today. So the discussion is, as we go forward, can we reach common ground, whether it be on a safe harbor approach or in a more ERISA straight preemption approach? I'm hopeful because I think that really makes sense. And irrespective of the history, the question is the future. We are competing today in this country against every other country in certain respects, certainly against China, certainly against many European models as they have their economies go forward. So we can't afford to be inefficient. We've got to be efficient. We've got to be on top of our game. So our proposal is to be efficient, to be as uniform as possible, and move forward.
Roger, I wanted to, oh, go ahead.
Along those lines then, so assuming it makes sense to federalize the employment laws, would it then not make sense to federalize everything? Because if the concern is that nation or international companies are coming into a state or a locality and having really, their HR people really have to struggle with like learning new law. That's not true only in the employment and or labor context. It's true in every context. And so do you not then have to make room in your argument for discussion about whether or not we just need to do away completely with all state and local laws? Because, I mean, really, if we're going to be efficient, we have to be really efficient.
Are you going to restate the question, or are we clear, I think?
Yeah, no, I think everybody heard.
So I think I have a 10th Amendment problem if I went that far. There are certain constitutional rights reserved for the states, and that's the way our federalism came about, the compromises of federal versus state. And you have to have a common sense approach to it. No, but I would agree with you. I mean, we're talking here today about labor and employment law. We have an Environmental Protection Agency, whether you like the people there at present or not. We have that agency. We have all kinds of other federal agencies. And they do have, to a large extent, a federal approach to issues. And I guess, ultimately, would you rather have decisions being made by input from all 50 states, or would you rather have the decisions being made in Mississippi, Alabama, maybe California? Is that what we want? I don't think so. So to the extent we're going to have uniformity, whether it be in labor and employment or otherwise, I think it's probably, as a general rule, better to have a federal approach, if you will. That would be my answer to your question.
Yes, Sam?
Roger, I'm not going to go quite the same distance as the prior question. In employment law, we're also talking about state civil rights laws,
Yeah.
state minimum wage laws, state occupational safety laws. Unless this is going to be the thin ERISA preemption, where it's a broad preemption but very little regulation, we're talking about an enormous federal bureaucracy. gonna take over all these laws, and we have many workplaces in the United States, and 350 million official people. I mean, you are going to basically substantially enlarge the federal government, substantially.
Well,
So
maybe
the question was whether,
I'm assuming you can't confront, is there something about leave that's special, or is this gonna be all state employment law in your view?
So-
Leave that's special, or salary disclosure that's special?
the question was whether Roger's approach would, either as he sees it or by definition, would have to encompass all types of federal labor and employment laws. State employment law, whether federal employment law should supersede all states' labor and employment laws, and doing so, if doing so, will substantially enlarge the federal government and lead to unintended consequences.
So what am I here, arguing for more federal government? Is that what you're saying? Yeah, to a certain extent I am. Yeah. So let's turn the question around a little bit. If you are a potential discriminantee of some type of potential hiring bias, would you rather have the EEOC or the Ohio Civil Rights Commission being your advocate? And I would venture a guess 10 out of 10 plaintiff lawyers that I know would say the EEOC.
Now, if you can afford a lawyer of Rachel Dean's caliber, I don't care what legal regime you put me in.
Well, that's a different
Now,
question.
If I'm
Yeah.
dependent on an agency, I want the Ohio Civil Rights Commission or the New York State Civil Rights Commission, because they're going to give me an adjudication that I cannot get before the
Well, I think you will. But at any rate, I think back to your question. Back to your question, though, Sam. No, there's certain areas. Now, OSHA all.
isolating these areas.
Yeah, no, let me answer your question. I mean, for example, OSHA, NLRA, et cetera, I think are all pretty well already, either by practice or by statute or custom, a federal approach. And minimum wage, no. I think the more intelligent discussion there, and we've had this discussion, that there can and should be variances. Similarly, even under the FLSA, we're having that discussion right now about exempt, non-exempt. Should there be, and there has been in the past, different quadrants of the country that have a bearing on setting figures? Sure, that makes sense. But what we're suggesting is that the basic structure, the basic tenets, the basic philosophies, if you will, should be a federal approach and have as much uniformity as possible. But there needs to be some variance. I mean, in particularly the minimum wage area, I would submit.
I think there's another
There's a
question.
question here. Sure.
Yeah, but most of it ultimately is deferred to the Fed.
There's a question back here.
I guess, Mr. King, you just took the minimum wage out of the argument, which I think is the obvious one, that the Chamber of Commerce could turn its considerable lobbying efforts toward making the minimum wage uniform by advocating an increase to match what California and New York pay, so that you have a pretty basic set. And as a federal employee, I'm all for this, and I think I would just ask that in addition to advocating for this, you ask for an increase in funding so that we can do this for you.
So I would support that, actually.
Yeah. But I think, is that the answer, that if the chamber turned around and said to Congress, we want more uniformity, do something? Are you the solution to your own problem?
Well, not just the business associations. We have an inherent perspective, obviously, but I would never, ever underestimate the input from organized labor. I know we all go to conferences and we see the decreasing membership of organized labor in this country. I can tell you from inside the Beltway, organized labor is a continual strong voice, an effective voice, thoughtful voice. They're far better organized in many respects than the business community. They're extremely effective. So you get a national perspective and a national discussion. I submit you don't get that in Sacramento. You don't get that in Alabama or Mississippi. And that's one of the central tenets of this discussion. We're going to have disagreements about where you land or where we land on legislation or policy. I think it's better to have that discussion at the federal level for a variety of reasons, including having many stakeholders and many perspectives. I do agree with the point was made just a moment ago. Many of the companies we represent do look to California or Connecticut or Massachusetts when they're putting together the leave laws. I mean, that's true. But then they're trying to decide how far do they go, and is that the right way to go about setting what's proper policy in this country? I don't think setting labor and employment policy in Sacramento is better than doing it in Washington. I mean, you and I may disagree, but I mean, that's our perspective.
But I guess Washington not doing it is why Sacramento's doing it, so if the chamber can get behind Washington doing something, then maybe the Sacramento will feel like necessary.
So the question is, at least Sacramento is acting. No, I get that, but that's why we have elections in this country. That's why we're going to have an election this November. And many people, at least I believe in, that follow Washington closely, think we're going to have a change in party control in the House. And we're going to have some very closely contested elections in the Senate.
Just, sorry, to put it another way, in most cases, the federal law is the floor. So any variation raises the minimum standards for workers. So you're talking about taking out, you're presenting it very policy or politically neutral, but it's not neutral because it doesn't lift anyone up to remove state and local protections. It only brings workers down.
No, that's only partially. Well, the question should be repeated. Did everybody here? I guess they did on the microphone. No, that's only partially correct. The National Labor Relations Act's not a floor. ERISA's not a floor. Those are comprehensive statutes. Some, perhaps it's a floor, but that's not the question. That's not the question I'm posing. The question that I'm posing is, shouldn't we have more uniformity? Shouldn't we have a greater ability to predict and to comply, whatever the ultimate standard is? And under the safe harbor approach, we avoid that argument altogether. You have a federal set of standards. If you want to comply, great. If you don't, then you can comply with the state law. That's what I think makes this safe harbor approach at least appealing for discussion purposes.
Got a question here? Let's see if we can get you a microphone.
Yes, I think my basic question is, assuming you employ 500 to 1,000 people.
Here you go.
I go back to, and you sort of like a lot of them, and some you don't like so much.
Harry, we want you to use the mic.
But you're really not discriminating on whether you like them or not. And you pay people based on likability. Well, why is that? Doesn't seem to go along. I mean, I like these 20. I don't like those 30. But the people I don't like are a mixed group. Different ages. Some are black, some are white, some are Jewish, some are Irish. So why can't I pay people based upon whether I like them or not? More, certainly. I pay on likability, because in fact, that's how people get paid.
I mean, people say this a lot, that the EPA is a strict liability statute, which means if you're paying two people of the opposite sex who are doing the same job differently, you're going to be held strictly liable unless your explanation for doing so falls under one of those exceptions. So, and then it depends on where you're employing people as to whether your explanation falls under the catch-all exception.
Can I just add to that, Larry? This was the first statute dealing with sex discrimination. The idea, it was also the first similar statute in the European Union. The idea of people are doing the same work, and one group is predominantly female, the other group is predominantly male, and there's a salary difference, and the only justification you have is you like them, then you have gender discrimination paid. That's the problem.
If it's a class thing that you're paying,
But it doesn't matter, you have two employees.
Two employees, yeah.
One male and one female, it's the same idea. You have to have a certain number of employees to be subject to equal pay. What is it, 20? Two, I think.
Well, you have to be like
I think it's
in
5.
You have to be
an establishment or an enterprise.
There's a minimum coverage requirement. You meet the minimum coverage requirement, you have 3 female employees, 3 male employees, and doing precisely the same work, and the only justification you have, I like the men. That's just another way of talking about sex discrimination in pay. Don't you see that?
but if you get paid for
just, but it does, I mean, it covers reverse. You don't have, it covers reverse discrimination too.
Yes, it does.
Right.
That's one problem with banning reference for prior salary, you end up hurting women. Other questions or comments? Amy, thank you, Amy, and thank you, the panel.
I want to thank the esteemed panel and all your good questions.